Okay, we're going to go ahead and get started. Again, thank you all for attending. My name is Ann Badmus, and I am with Badmus Associates. And welcome to our Thursday, February 26th webinar about H-1B visas. So let me just go ahead and get to my screen. Gosh, here we go. Here we are. Okay, so as I mentioned, our webinar today is about H-1B visas, our 2026 survival guide. And so we're going to go through a few things that anyone who's interested in the H-1B visa should know about the process this year and hopefully guide you through that process. So before we get started, I do want to ensure that everyone who is joining us knows that this guide is really a information or presentation for information purposes. Immigration law is so complex, and so each individual situation, there's always some distinctions and differences. So while we can only provide general information in this format, we welcome you to reach out to us for more specific legal advice regarding your immigration matters. So during this webinar, you can ask questions at any time. So just put your questions in the chat. And of course, as you're asking the questions, this is a public forum in some respect. So be sure that your questions are general in nature and does not reveal any personal information that you would not want to be known outside of with your attorney. Okay. So our agenda today is basically to cover the basics of H-1B visas. Some of you probably have some familiarity with it, so it may seem like something you already know, but we just want to make sure that we cover the basics and then go more into detail with respect to the H-1B cap and the changes that are going to take place for this year, as well as options of cap exemption, which may be a route that some can take in order to avoid the requirements of the limitations of the H-1B cap. Then we'll talk about timeline and key dates, and then just briefly about some anti-fraud measures that the government is undertaking based on its perception or policy to try to make sure that the H-1B program is compliant and not being abused. And then we'll have some time for question and answer as well. So as I mentioned, we're going to talk about H-1B basics and the specialty occupation requirements. So H-1B, let me just remove this, requires that the position that is being offered to the potential H-1B employee is a position that at least requires a bachelor's degree or the equivalent in a specific specialty occupation. So we'll talk more about what the requirements of a specific specialty occupation is, but I do want to mention that the bachelor's degree or higher can be a foreign degree if the degree is considered equivalent to a U.S. degree, or sometimes it can be consisting of experience. So for example, the government says that for each year of college, you can equate 3 years of experience to each year of college. So for someone who does not have a formal bachelor's degree, if they can show that they've obtained 12 years of experience in the field, then they could be considered as having a bachelor's degree. So that is another thing to think about if you are having someone who maybe your position does require a bachelor's degree. However, the individual may not have that degree, but they may have experience or a combination of education and experience that could qualify them. Then, of course, we also need to be sure that there is an employer-employee relationship, which basically means that there needs to be a separate entity, an employer, with its own tax identification number, its own corporate structure to sponsor the employee. Usually for H-1B, you can obtain up to 3 years at a time for working or what we call a validity period of the H-1B, which allows the worker to work for that specific employer for that period of time. But in general, the most that an individual H-1B worker can have as far as time on H-1B is 6 years, unless that individual is in a certain stage of the green card process, which would allow for extensions beyond the 6-year limit. And then finally, there is always a requirement. And again, these are basic requirements. There are certainly other requirements as part for H-1B in terms of compliance, but these are the basic things that should be known if you're considering to hire someone or if you're considering to be employed in H-1B status. So the prevailing wage or actual wage is the minimum requirement. So what that means is that the employer must agree to pay the H-1B employee or the potential H-1B employee at least the higher of the prevailing wage or the actual wage. Now, the prevailing wage is determined usually by a survey, a public survey, usually determined by the Department of Labor, where it qualifies or it does surveys of local areas and different occupations and says this is the minimum wage I want to make a distinction, not minimum wage as we know, as we hear about, but what we're talking about a prevailing wage. So for this occupation, this is the usual wage that should be paid to someone in that occupation. So for an engineer, for example, if in the Dallas area, the prevailing wage, the government says is $75,000, for someone of entry-level position, for example, then that person needs to be paid at the minimum of $75,000. However, if you as the employer typically pay your entry-level employees or engineers of the same qualifications $80,000, then you must still pay that H-1B employee $80,000 as well. So you cannot drop that wage to $75,000 just because that's the prevailing wage. You must agree to pay the higher of your actual wage or the prevailing wage. If you pay lower in your practice or in your company than the prevailing wage, and even if other employees who are U.S. citizens, for example, are being paid lower to hire that H-1B employee, you must agree to pay the prevailing wage, which may be higher as well. So next, I want to really talk a little bit more about specialty occupation. So as I mentioned in the previous slide, it is a requirement that the position require a bachelor's degree in a specific specialty occupation. So when we talk about specialty occupations, we're talking about fields where there's very specific education that's necessary in order to qualify and work in that field. So if you have someone who might have a degree in general studies, that might not be specific enough to qualify for an H-1B. So you really do have to look at not only your requirements, but also the degree that the individual has. But what the government has said, or the Congress actually has said, is a specialty occupation, is any profession that includes architects, engineers, lawyers, physicians, surgeons, and teachers. Now, that's what Congress listed those occupations, but we must note that it says it is not limited to. So as a result, of course, there are many, many more occupations than the architects, engineers, lawyers, physicians, and surgeons and teachers that qualify for H-1B. But if you are in one of the listed occupations in this regulation or this law that Congress enacted, then you are automatically considered to qualify for H-1B as a specialty occupation. There should not be any question by the government as to whether or not you qualify or whether the position is a specialty occupation since it is listed. However, if the position is not listed in this code, then basically we do have to explain or show the government how our specific position still qualifies as a specialty occupation. And this has fluctuated over the years, especially as occupations change with technology and technology occupations and all different occupations that come up, all the time as our society progresses. There's going to be different occupations that were not necessarily considered 30, 40 years ago when this law was enacted. So what the government does is that it wants you as the employer to prove, you're the employer, to prove that your job is a specialty occupation. So in order to do that, there's some guidelines that they give us, and we want to make sure that we're meeting those guidelines in order to qualify. So as I mentioned on this slide, bachelor's degree requirement. of course, that must be a bachelor's degree requirement to begin with, but it must be a very specific bachelor's degree that you're looking for. It could be multiple degrees, but you have to then show why each separate degree would qualify for your position. So, for example, this typically comes across in IT positions where we say we'll accept engineering, we'll accept engineering degrees, we'll accept computer science degrees, maybe even a business administration degree. Then you are going to have to prove how those degrees actually do relate to your position and that they are specific enough in terms of the education to qualify. So, of course, if you're just requiring a broad degree like liberal arts, or even, as I mentioned, business administration without a specific focus like business administration and accounting or information technology or something like that, then it might not be sufficient for the government to agree that your position is a specialty occupation. So you absolutely want to, as you're looking at your job description or developing or as you're looking at or either developing if you have a new job description, you want to focus on what degrees will qualify and how they're directly relevant to your occupation or your job offer. So, and we'll talk a little bit more about that as we talk about the evidence that you might want to be sure you have. So another part of the H-1B minimum requirement is, of course, as I mentioned, the employee-employer relationship. So that also has been quite a bit of fluctuation and focus of the government or changes in the government and how they review. Sometimes, depending on the administration, what might be considered employee-employer relationship or evidence enough of it, it could be different in a different administration. So we always have to keep up with what the government is saying is an employee-employer relationship. So what that means is basically that, first of all, it is I guess what we call a W-2 position. So this is not an independent contractor situation that does not qualify for H-1B. So you must be, as an employer, an actual employer of an H-1B, of an employee who does receive a W-2 for proof of their compensation. So you also need to prove that you actually have work available for the employee. Now, some positions, it may not be that much of a need to provide that information. So, for example, if someone is a doctor, well, if the doctor sees patients, you're not going to really have, in most cases, especially if they're working in a clinic, they're not going to have contracts with the patients. It's basically they're going to be there on a daily basis, providing medical service to patients or in a hospital. But in other cases, you might actually have a limited scope in terms of, or you might be very contract specific in terms of clients. So, for example, in IT again, and this is where there's been the most, I guess, controversy is that if you have a IT position or a employee that is going to be an IT position and you are expecting them to work on certain customer contracts that you have, then you are going to have to show that there are contracts there. If you are just, or if you are actually maybe software development and there's not really a customer contract, but you're generally developing software, not necessarily for specific contracts, but for sale to the general public, then you may not need to show that. So it really is depending on the type of position that it is and the type of industry that you're in. But you do need to, in some cases, be very, very specific in terms of what kind of work you have available for that H-1B employee. So it must be an actual job, not a potential for a job for the employee to work. You must make sure that all the documents that are part of the H-1B application, especially the labor condition application, which is the application that is administered by the Department of Labor, where you explain what the position is and what the job duties are and what the salary is. You must make sure that all of your documents, your pay records or your pay offer letter, all those things line up with what the labor condition application says, or what you put into the labor application, and also what you indicate in the H-1B petition as well. The last point here is real job offers. As I mentioned, there must be genuine work available, but this can also include remote or off-site work. So if you generally have remote workers, they can work remotely, but you still have to show that you have an H-1B employee can work remotely, but you do have to show that there is actual work for them to do. Now, speaking of employer-employee relationship, uh, even though it doesn't quite seem to make sense, but it is allowed that the H-1B worker can actually own all or part of the company that is sponsoring him or her for an H-1B. So there is an H-1B self-employment option so that if you are someone who's entrepreneurial and you are in a specialty occupation, you can potentially set up your own company and have your company apply for your H-1B status. So that has always been the case, at least in our practice. We've done that for many, many years. But last year it was more formalized with the USCIS or the government, where they had more specific guidance on how that would work. And so far in the past year that we've been working under this guidance, it has been approvable. Cases have been approved for those who actually own their own companies and are sponsoring themselves for H-1B employment. So some examples would be medical facilities, for example, a physician that owns their own practice and is also working in their practice as a physician. It could be information technology again, it could be engineering, it could be architecture, it could be pretty much any professional position that would qualify for H-1B. And so even if that employee owns some or even all of that company, they can still apply for an H-1B. But they do need to show, if you are an H-1B owner, self-employed, then you need to show that you are going to be spending most of your time, over 50% of that time, doing your specialty occupation work. So it's not about you being an entrepreneur and managing a business. It's more about you being an entrepreneur, but you're also providing services within that business to your clients or customers or patients. So you would have to show that you are actually going to be working in that specific field. But there can be a balance of mixing your business management duties along with that specialized work. But your specialized work as a physician, as a teacher, as a architect, whatever that may be, has to be your main focus. The other difference that has happened in the past year in terms of qualifying for this particular type of H-1B is that the government does limit the timeline or the amount of time or the validity period, I'll put it like that, that you can have an H-1B under this type of arrangement. So the first time you apply as someone being self-employed, then you will get a 18-month time frame, and then the second time you can extend it for another 18 months, and then after that you can get the usual 3-year timeline. So that's a small difference there, as opposed to someone who is not self-employed and being sponsored as an H-1B. Usually the employer can get an initial 3 years for that work as opposed to 18 months. So let's move on now to the H-1B cap. That's something that is certainly happening this time of year. So I want to make sure that we understand what the requirements are because there are some changes from the previous years. So basically the H-1B cap applies. Well, first of all, the cap itself, the numbers are as I depict here. The regular cap, which is basically those who have a bachelor's degree, is 65,000. The master's cap is expands to give 20,000 to those who can qualify as having a U.S. master's degree, meaning a master's degree, the master's degree or higher that they obtained in the United States. So overall, there's about 85,000 H-1B visas, new H-1B visas available each fiscal year. And this cap applies to new H-1B employees. It also applies to those who may already have an H-1B. And they are considered what's called cap exempt, which I'll talk about in a minute. And now they want to change to an employer, a private employer, for example, that would be subject to the cap. So that would apply to that type of H-1B worker as well. And it would also apply to those who may have had H-1B, may have been counted in the cap many years ago, but they fully have used their six years of H-1B time. They're not able to extend because they haven't applied for the green card, and they've returned back to, or they've left the US for a year or more, and now they're trying to come back on H-1B. They would be considered a new H-1B employee and would have to start over again into the new cap as well. There are some other distinctions, but we don't have time to go into all of those. So I just wanted to give you the general idea of who is subject to the H-1B cap. So the H-1B cap, so that means, of course, that there is because of that limit, and usually there are more people or more employers and employees interested in applying than there are visas available. The government has to decide who will be able to get one of those, or at least be able to apply for one of those H-1B visas. So just to give an idea, last year the numbers of applicants were over 400,000. Our registrations were over 400,000. And so my understanding from what the government said, it's I guess statistics on that was that there was about a 29% chance for someone to have been selected in that lottery. Now that was a random lottery. In the past years, it has been random for the past 5 or 6 years that this lottery system has been in place. However, this year there is a new lottery rule where it's no longer going to be strictly random. There will be some randomization as I list here. However, depending for each person, each beneficiary, which is the H-1B employee, depending on what their salary, what their wage level will be, may have a better chance. So the way that the government has indicated, and again, this is new, so we have no idea, how that's going to turn out statistically at this point. But what the government will do once they receive the registrations is that they will base their selections on a weighted process or a weighted scale. So that weighted scale means that they're going to have the employers register and include the wage level that they are offering to the employee in that registration. And if that registrant is receiving a very high level 4, which is the highest level in the wage level system, then they're going to have a 4 times registration. So basically, they're going to have 4 points. And someone with level 3, 3 points, level 2, 2 points, and level 1, 1 point. So as someone who has a higher level is going to be able to be considered having those 4 points or 4 times as registration. So they're going to potentially have a better chance of getting an approval or getting selected, as opposed to someone who's only at level 1. So again, this is a new process, very, very new, and starting on March 4th and ending, we will know by the end of March who will be selected, and maybe get some statistics from there as to how this system worked out. So, but in any event, for employers, it's very important to understand the wage level. This is related to the prevailing wage that I discussed earlier. So what they're looking at is, are you working with a higher level H-1B, probably more experienced person, as opposed to a new grad, for example. So this is where you would find the OES wage survey that was mentioned in the previous slide as to how they are going to determine or provide points or to these registrations. So this is the website, and this website is also used for the actual H-1B petition as well when you apply for the H-1B if selected. And so basically you would go to the website here. It would indicate, first of all, you would be picking the year of the wage, and usually it would be the most recent year, so 26, 25, 26 year, and then you would pick all industries if you're a private employer. If you are a university, this is the only time you would pick this section if you were in higher education. And then the occupation itself would be chosen. So you'd have to make sure that your job description is very well defined and meets an occupation that's listed here. And then it will generate for you the different wage levels that are available. So we don't have time to go into specifically on those, but I wanted to make sure that you saw where you're supposed to find this information. So now I want to talk about ways to potentially not have to go through the H-1B cap for any new H-1B employees. So the definition, so there is what's called a cap exemption, and so it's very important to understand how that works. If a position or an employer is cap exempt, then that means you do not have to go through the process of the lottery at all. You can actually, as an employer, apply for the H-1B employee any time of the year without concern about any limit to the numbers of H-1Bs. So this is a great advantage, but you do have to meet very specific criteria and prove that you would be considered cap exempt. And what I mean, the employer needs to prove that. So who are cap exempt employers? Well, it's very narrow. There isn't a lot. It's not everyone. Usually private employers are exempt, except with one exception, which I'll discuss in a minute. But institutions of higher learning, these are public or nonprofit colleges and universities, can always apply for H-1B without concern for the cap. If the organization or the hiring employer is a nonprofit, 501c3, and they have some kind of affiliation with a higher education institution. So for example, if they're providing internship training for a local university, that could be in medicine, that could be a lot of religious organizations have training involved. It could be not nursing, but it could be other areas as well, where you're basically offering an internship or a program in affiliation with a higher education institution, then you could be considered cap exempt as well as an organization. Then least used would be those that are nonprofit research organizations and government research organizations. So generally, if we find cap exemption, we usually find it in one of these two areas. This is where they're mostly used. And where there's opportunity usually is if you are a nonprofit and you have an affiliation. So even if you are not a university, you may still be eligible for cap exemption for your H-1B employee. So how does that work? There are some certain advantages or ways that you can, even if you're a private employer, can take advantage of cap exemption. So the first one is the at-work rule. And what we mean by that is that even if you are not a university or not a nonprofit with an affiliation, but you're a private employer, and that your H-1B employee will potentially work at either a university or a nonprofit affiliated organization at least half of the time, then that H-1B can be cap exempt. So this is what we call a third-party cap exemption. And a typical example that we run across is, again, in the field of medicine, where physicians will be working with a private medical group, but they will be working at a university hospital or the university affiliated hospital. And so they're able to, at least 50% of the time, so they're able to get an H-1B exempt from the cap. There could be other situations as well, but that's just a typical example. Then there's another, what we call a concurrent workaround. So if you're a private employer and trying to avoid the cap, or an employee, H-1B employee that wants to avoid a cap, but you have a private employer that would be cap subject. So if you want to avoid the cap or you don't get selected in the cap, if the employee can find a cap exempt employer, maybe part-time, maybe 10 hours a week or whatever is feasible, and work for that cap exempt employer the part-time, then you're able to also get another H-1B with a cap subject employer. So an example of that is an employee that maybe has a part-time teaching position at a hospital, not a hospital, at a university or a college. And in that case, their H-1B is cap exempt. having that cap exempt employee, they can work full-time or another part-time position with a cap subject private employer without going through the lottery itself. However, the time that they can do that, or the time frame they can do that, has to match up with their cap exempt employment. So if your cap exempt employment is for 3 years, your cap set and ends on June 30th, 2027, for example, then your cap subject employment ends on the same time. So, and you always have to maintain both those employment positions in order to continue not having to go through the cap itself or continue with that type of arrangement. Also, it's important to know that if, as I mentioned before, if you are strictly cap exempt employee and now you want to work for a cap subject employer, and you've never been counted against the cap, then you do need to usually will need to enter the lottery unless you can do these workarounds that I mentioned before for cap exemption. Okay, so let's talk about the big question, or the big news that came out about 6 months ago for the $100,000 entry fee. Caused a lot of controversy, and in fact, there's still lawsuits going on about the validity of this fee. But as many of you probably know, the president proclaimed on September 19th or 20th, 19th, I believe. That was a Friday evening, that on Monday, there would be $100,000 fee attached to certain H-1B applications. So fortunately, it didn't apply to any of those that were already pending or already approved, but going forward, there were certain applications that would be subject to that fee. So that fee, again, started on September 21st. It was supposed to expire this year, September 21st, 2026. Of course, it could be subject to extension, or depending on if the lawsuits that are pending are successful, it could be eliminated altogether. But currently, the USCIS is charging that fee for those for the situations that they apply. So what do they apply to? They do not apply. They only apply to those who are outside the U.S. and needing to obtain an H-1B visa to enter the U.S. in order to work for that H-1B employer. So it does not apply to, I don't know if it's maybe a majority of people who are already in the U.S., either in student status or some other status, and they're applying to change their status or extend their status to H-1B. And in that case, the fee does not apply. So in most cases, if you are hiring someone who's already in the U.S. and you're able to obtain an H-1B visa and request either a change of status or an extension of status for that person, well, change of status if they're a new H-1B, but an extension if they're already here, then an H-1B status, then that $100,000 fee does not apply. So it's not a blanket fee that applies to any new applications. You really have to look at the circumstance and see if that is a requirement of your particular type of employment. But if it is determined that if you are bringing someone who is not in the U.S. that needs to come to the U.S. and first of all get the H-1B visa approved and then apply for the actual visa at the U.S. Embassy outside the U.S., then we are seeing the government requiring that fee be paid, and that fee must be paid by the employer. Because as like most H-1B application fees or petition fees, the employer is responsible for payment of those types of fees. Okay, so let's move on to timeline and some key dates to consider. So if you are considering the H-1B lottery, so the registration period is starting pretty soon, next week, March 4th, and it will run until March 19th. So that is where you need to prepare to obtain the information to be able to submit your registration within that time frame. Then after that, the government is supposed to conduct its random selection, and it will be random in the sense that they're not picking for specific companies or things like that. But if you have your wage level, as I mentioned before, there will be greater chance of being selected for those who have higher wage levels. So that's supposed to be announced March 31st. So the registration online, if you're selected, you will see the selection there in your account. So once selected, then the next step is to actually apply for the H-1B visa or file the petition. So just being selected does not get you the H-1B. There's still there's still requirement that you provide certain information to qualify for the H-1B. So between April 1st and June 30th, employers must file their H-1B petition. And it is a very hard deadline. If it comes in, if you deliver that application after June 30th, then you would have lost the opportunity. They do not extend that deadline. So it's very important to start, if you're selected, start right away to prepare and ideally file well before June 30th. You do not want a situation where you're filing last minute and maybe FedEx doesn't get there, or there is an online system as well. So you could do that optionally, but it generally, it generally does not, sometimes, well, it can sometimes crash. So you want to be careful not to be waiting last minute, especially if a lot of people are waiting last minute and trying to file online. There could be glitches that happen. And so that could also affect you. But once you file and the application is submitted and receipted, then depending on whether you filed regular process or through premium processing, if you filed regular process, it's not really predictable how long it would take. It could be quick, or it could be months and months and months before you hear back. For premium processing, it's guaranteed 15 days. But in any event, the start date would always be October 1st. It cannot be any earlier than October 1st. That is when the government fiscal year starts, and that is when the H-1B actual visas are available at that time. So that would be the starting date if approved. So let's talk briefly about the cap gap extension, because there are many students who have graduated from U.S. universities, and they've been working as part of their F1 student status. They're allowed to work up from 1 year to up to 3 years. And so basically, if the student has what's called OPT, which is a work authorization, and their work authorization is expiring and they have no opportunity to extend it, for example, if that student is entered in, or that student's employment is entered into the H-1B lottery, and the student and wins that lottery, the next step is to file the H-1B application, as I mentioned. Once that application is filed, the F1 student now has extended his or her employment authorization so that they do not need OPT any longer. So as the example says here, if this student is selected and applies for the H-1B this year before the June 30th deadline, and if their OPT expires June 30th, or even May 30th, or whatever timeline there, August 30th, whatever date it is, since that H-1B petition was filed, now they can continue working automatically through their OPT work authorization up until April 1st next year, 2027. That's to give time for the H-1B process. If you're not using premium processing, it may take 6, 7, 8 months. And so this way, the OPT student can continue working with their employer without having to stop working because their OPT has expired. By the fact that they have an H-1B application pending, that gives them an automatic extension up until April 2027. Before last year, it used to be up until October of the year. So in 2024, it would have been up until October 1st, 2026 that it would apply. But now we have more time. However, if the H-1B application is denied, then all work authorization ends at that point, and then the student may need to consider other options to stay or to leave the U.S. So if you're planning to prepare for the lottery, I know many of you probably are already, but it's very important that you get all the details together as soon as possible, especially a detailed job description, because as I mentioned before, you need to be sure that your job or be reasonably sure that your job is going to fit into the specialty occupation. You also want to look at the prevailing wage and actual wage to see what wage level you can agree to pay as an employer, or as an employee, what wage level you'll receive. And that wage level will determine the chances of winning in the lottery. You also need to be sure if you have multiple job locations to know where they are, because H-1B is very job location specific. The employer needs to make sure they have all their information, their official name. They especially needs the tax ID number, the EIN employer ID number. And this is really important if you have multiple organizations. Please make sure you're using the right one, the one that will actually be issuing payroll to that employee. And then, of course, you need to have all the other information there about contact information and having someone in the organization that will be responsible for receiving information about the H-1B. So, of course, the employee information is important as well, passport, all the immigration documents that they have, and then determine the education, whether they would qualify for master's degree cap or whether they qualify. If they are looking at master's degree cap, then you want to be sure when will they have their degree. If they're still in school, but by the time, let's say by June 30th, they will have their master's degree, then they could still qualify for the master's cap. So next to last, I just want to briefly talk about avoiding common RFEs. So RFEs are requests for evidence. So when you file your H-1B petition, if you've been selected, or even for cap exempt H-1Bs, they're all the process is the same, whether you're cap exempt or cap subject, the applications are identical. They're going to be looking at the occupation and other criteria to be sure that they do qualify for H-1B. So in particular, we are seeing more and more RFEs overall from the USCIS. They've stated their RFE rates have gone up in the past year. And so what we see for H-1Bs is very, very important that employers and employees know. You want to make sure that job description is not vague. You want to be very specific, showing what kinds of duties, if possible, the percentage of time spent on the duties so that you can show the complexity of that job. Want to make sure that the degrees, don't say any degree, you want to say specific degrees, and do not expand unnecessarily. Or if you feel like the H-1B employee does have a degree that matches, but typically you haven't, used that degree before, had an employee with that degree before, think about exactly how you can prove that that degree does qualify for your position. So you want to be sure the wage level is not mismatched with the complexity of your job duty. If you're looking at entry level, but you're giving someone, if your wage level is entry level, but you're asking them to do duties that will be very, very complex, and probably someone with more experience should be working in that type of position, then you want to look at that because they may really need to raise that wage level. Then if you are a company or an industry, a company that has employees working with an end client, either on site remotely or working on site with that end client, you want to be sure that you have any agreements in place or proof that you can show that you actually have a client that will, that the employee will be working with. And then be sure everything is consistent with your forms and support letter and all those things. It's very important to be very consistent. And then finally, I do want to let you know about what we call integrity measures and anti-fraud. So this has been around since 2006, so it's not necessarily new, but last year it was codified into specific regulations where the government rules and regulations where the government has now made it pretty much official that work site visits can be standard as part of the process for H-1B visas application, even while the application is in process or after the application is approved. It is possible for the government to send one of their investigators from their administrative site visit and verification program to visit the employee or employer work site or where they expect the employee to work, to verify that employee is actually working there or has a position there. They may come to interview staff and want to check certain records. They might want access, they will want access to all work locations, even if it's remote work at home, those locations they would be looking for. So it's important to document those things and have your paperwork available. And we will, that's a whole another another presentation, but there's specific things that can and should be done in order to be able to pass this type of inspection as well. So we've gone through quite a bit, and I know there were some questions in the queue. So let me go ahead and see if there's any questions that I can answer. There is a question here that someone has about, based on previous slide, does that mean that the $100,000 fee does not apply to extensions? And yes, that is correct. Typically, it does not apply to extensions as long as the person is extending in the US. So there can be situations where you might consider an extension, and then let's say for some reason the government says you're not able to, they're not able to provide an extension, that they can approve the H-1B classification, but you will need to apply at the US Embassy to reinstate. And that could be a case where the government might not agree that the employee has maintained H-1B status. That's rare, but it does happen. But in general cases, if you filed on time, there's not been any issues with maintaining status and those types of things, then the H-1B, the $100,000 fee should not apply to the extension at all. Let's see. Are there any other questions, concerns? Okay. Well, with that, let me see, I just want to review briefly. Well, thank you all for attending. Again, I just want to confirm again, or to let you know that this is I think I see one more. Okay. I'm sorry. Somebody did ask, do we handle EB-1 applications? And yes, we do. We handle quite a few EB-1s. That's one of our primary areas. So certainly do reach out to us if you have a need or would like to discuss an EB-1 application. So, and this is where you can actually reach out to us and either by calling or emailing us. And so we can certainly help you with that. So thank you all again for attending. We hope you all have a great day. And if you do have any questions, feel free to reach out to us. Thank you.